Right, this is lovely words.
You good? Yep. Call the meeting to order. We're live.
Definitely not live, because she did not just put on my glasses.
Okay, welcome back out then.
There you are.
Can you wave your hand?
That's live.
Okay, that's live. I think we're good. Okay. Hopefully we're live. Call the meeting. October 1st, 2024. Meeting of the Westminster Zoning Appeals. Start with introductions. I'm Scott Brick, the chair of the BZA.
And Brenda Fraser, and board member.
Karen Roth, Board Attorney.
Joe Aiken, Planning Department. Item number 3, we're going to scratch that. Do you have motions to do that, or can we just dismiss it off the agenda?
Right, I would just make a statement that we're amending the agenda to remove that. It was erroneously.
It was a clear. Carry over from a couple of months back, election of officers. And item number 4, approval of meeting summaries. Staff is informing me that the May 7th meeting, July 2nd meetings for Shepherd staff and Outback Steakhouse, those minutes will be forthcoming at a future. So that as well. And item number 5, approval of the final decision letter. BZA -24-04, signed for Outback Steakhouse.
I moved to approve the final decision.
Second. All those in favor?
Approved.
Yes, it is. Before we begin, the public hearing on case number 24-07, Steve. Yes, sir. This is already signed. Registered. Yes, sir. Dave or the city attorney have anything to add before here? Yes, sir. We're meeting for a variance appeal application by Marta Corsi, the applicant requesting a 105-foot variance from the 300-foot distance requirement of the City of Westminster zoning ordinance, section 164-5A at lot 5A, located on Criers Church Road in Westminster, Maryland. Any staff report goes first, or do we have the applicant? Oh, yeah.
I think the applicant.
I think when we redid the rules of procedure, we had to have you looking for this.
And so I guess swear in.
Yes, please.
If anyone here this evening, either the applicant or neighbors or representatives, if you wish to speak, if could be sworn in, do you promise to tell the truth, the whole truth, and nothing but the truth? So we can. I do. And with that, we'll turn it over to the applicant or representative.
Thank you. It's me this evening, and with your permission, I'll remain seated here. Good
You identify
evening.
yourself.
Yes, I will. Thank you. Good evening, Kelly Schaefer Miller, 73 East Main Street, Westminster, Maryland, 21157. I am here this evening on behalf of the applicant, Ms. Marta Corsi. I have with me Ms. Corsi, who's seated to my right, and also Mr. Bechtel, who's seated to my left, who has prepared the plans that accompany the application that is before you tonight. A few introductory comments about the property. The subject property is currently undeveloped. Marta has been in this process for several years now. We'll get into just a bit of the history here later. But it is zoned IR, industrial restricted in the city. It borders shelter systems. Marta is the owner of the property. If you recall, I believe, Bridget was here in past hearings. At that point, she was not the owner. She has taken ownership of the property at this point in time. To the north of this lot is lot 4A, which is dedicated for the county's airport project and is currently to remain undeveloped. Lot 6A, which is to the south, is also currently undeveloped. So this is a lot of IR zoned property in the city. On March 6, 2018, there was case 1802, which was the first BZA special exception case requesting approval for the dog training facility at the site. That was unanimously approved as part of that hearing. Through the site plan process, it then became necessary to request a landscaping variance. So we returned to the board on December 3rd of 2019 and requested a landscaping variance at that hearing. That was also unanimously approved. Here tonight, we are here hopefully for the third and final time. This is probably a record of a project for me appearing for BZA, but we were very hopeful tonight that we can show to you and meet the variance standard for this distance variance. As you can expect, the last variance standard was met in the landscaping case, so we will present testimony tonight that those characteristics remain relevant to the variance that's being requested of you tonight. I do want to clarify or confirm for you that the building location has not changed since that initial hearing back in 2018. It's just that as a result of continued site plan review, it was the interpretation of the zoning administrator that this distance variance was necessary. That is why we were before you. So if you do recall those plans that were before at least one of you several years ago, the building has not changed location. It's still in the same location that you have reviewed on during the March 6, 2018 hearing and the December 3rd, 2019 hearing. The variance that we're requesting is from the required 300 feet to 195 feet, which puts us at a total variance of 105 feet from a dwelling that is located in the conservation zone and is across Criders Church Road. So this is our last pivotal step, and you'll hear Marta testify to this before Marta hopes to be able to appear before the Planning Commission for final site plan review. This has been several years in the making. Marta started by exploring property in the county, then made it into the city, and we've been through quite a process. So we're very hopeful that we are nearing the conclusion of that process, and Marta has invested even additional in this property, having now purchased it and continuing through the site plan process. So like I said, you will hear testimony tonight from Marta and from Randy Bechtel to the variance standard. And with that, I will begin the testimony. So first I would call Ms. Marta Corsi. Marta, can you please start by introducing yourself, stating your name and address?
Marta Corsi, 2424 Albert Row Road, Hampstead, Maryland, 21057. 1156. 210. I can't think. 21074.
That, okay. Can you please start by just giving the board a little brief synopsis of the business that you're in?
My business is dog training. Currently, we do multiple kinds of classes. We do manners classes, just basic obedience type things, agility, rally, nose work, tracking, confirmation. So just a whole lot of different kinds of classes.
And again, just briefly describe to the board your experience in the industry.
I've been training professionally since 1999. I became a certified professional dog trainer in 2003. I started my business as an LLC in Hanover in a storefront about 2010. moved here to Westminster to my current location, which is in the Air Park. In about 2013, 2014, and we've since expanded to take over 2 other pieces of leasing property. That's how much the business has grown.
And the name of your business, just to confirm, is not K9 Buddy, correct? Okay. And you just spoke to your existing location and the expansion at that existing site. Is it accurate to say that the size of building is necessary for your industry, for your business?
Yes, for my business to continue to grow.
And that's because, I state the obvious, that you train indoors, correct?
Correct.
Okay. So do you recall approximately when you started pursuing development of your own property for your business?
About 7 years ago.
And is it true that your journey started through the county looking at agriculturally zoned property?
Yes.
And then you came to find this industrially zoned property in the city, is that accurate? And then after that, you initiated a text amendment to allow for this use as a special exception use in the IR zone, is that correct?
Yes.
Then you also went through an amended plat process to carve up the lots as they exist currently, is that correct?
Yes.
And you heard me state in my opening, but I'll ask you to confirm that on March 6th of 2018, you appeared for the first BZA hearing requesting approval of the special exception.
Yes.
And since then, you have purchased the property.
Yes.
Has anything about your initial special exception request changed since we were here before this board in March of 2018?
No.
At that time, was the building proposed where it sits today?
Yes.
Through your continued review of the site plan, is it your understanding that the zoning administrator requested that you return to this board for this distance variance?
Yeah.
Is it accurate to say that give us a ballpark of how much money you have invested in this property to get to where we are today?
Probably close to $1 million.
And is it accurate that this is the last sort of substantive element needed prior to going to the planning commission to request site plan approval?
I sincerely hope so.
And in terms of the use, you just described your business and what you do and what you do inside of the building. But is there any dust, noise, odors that are generated from your building that would negatively impact surrounding properties?
No.
Those are my only questions of Ms. Corsi. I next intend to call Mr. Bechtel unless the board has any questions of Ms. Corsi at this. Mr. Bechtel, can you please, well, actually, I should open my client to cross-examination, I believe, Ms. Rush.
No, let's see. So right now it says we have the petitioner or appellant, city staff, then we have supporting testimony, then opposing testimony, rebuttals or rebuttal. Really we haven't provided for cross-examination necessarily, but yes, it would be appropriate to allow anybody here who might want to ask questions. But would you want to reserve that till later, or do you want to do it as you go?
I'm fine, we can, why don't we have, if it makes sense, we'll have Mr. Bechtel testify because he might answer some questions that people have, and then we can open both of them for any questions the public if that's acceptable. Okay. Mr. Bechtel, can you please introduce yourself, stating your name and address?
Sure, Randy Bechtel with Big PR LLC, 150 Airport Drive, unit number 4, here in Westminster, 21157.
Mr. Bechtel, what is your profession?
My profession for the past 40 years has been land surveying, civil engineering, and land planning here in the Westminster, Carroll County area, most of the surrounding counties.
And in that, in your career, have you testified in front of this board and other boards throughout the county as an expert previously?
Yes.
I'm prepared to ask Mr. Bechtel the qualifying questions if the board desires, but I would ask that he be qualified as an expert in the area of land use and planning.
I'm comfortable.
Thank you. Mr. Bechtel, tonight we're here really doing a hardcore examination of section 164, 161 of the city code, which governs the board's authority to grant a variance. So I'm first gonna walk you through some questions relating to whether there are exceptional or extraordinary circumstances or conditions applying to the property here tonight. So first, I'd like you to explain to the board the Criders Church right-of-way width in comparison to what exists for the Criders Church Road.
The recorded right-of-way for Criders Church Road is 80 feet. The pavement width is approximately 35 feet. Our lot is about 25, our boundary line is approximately 25 feet from the pavement.
And that right-of-way area that is on our property for that road prevents us from developing within that area. Is that accurate?
Yes. Very much.
Now, that width of right-of-way, do you believe that that width of right-of-way is, it does not apply generally to other properties necessarily in the IR zone?
Other properties, the right-of-way obviously was set up for a very intense use with truck traffic and so on for that to be, for the road width to be added to, maybe even to a dual lane sometime in the future. But for less intense uses, you would have a much smaller road.
And can you describe to us also the topography and nature of the rear of this property? And
Sure.
when I'm talking about the rear, just because I'm terrible at north, south, east, west, I'm talking about facing the front of the property from Criders Church Road.
And
May I ask, is the plan you're about to use already in the record?
it is not,
No, I mean, he's marked up the initial, or one of the record plats.
the grading plan for the site plan.
I just wanna make sure we enter
Yes.
the exhibit.
And I did bring, if that's helpful,
I think we're exhibit 7.
that would be helpful, so we can tell me what that was.
What we have here is the grading plan for the site itself. And reported on the record plat, I take it everybody made the site visit, familiar with the site. About 30% of the site in the rear is not usable for anything. It's where that big channel is. They carry the runoff off of the airport run.
This is not intermittent or anything.
No.
It's a drive it.
With a very, very steep slope here. There's a forest conservation easement on there. There's, right now working on a water resource protection easement that would be in this area. These are slopes greater than 25%, which are non-buildable. So what we're showing here, approximately 130 feet from the rear line onto our lot is really unusable. We cannot move the building back a whole lot further than where we are right now. And this is shown on the record plat from 2004 from the original subdivision, and then again when the revisions were made, in 2018.
May I please ask that exhibit 8, what's been marked as applicant's exhibit 8, please?
And can you read what's in the block on the right hand side, so we can,
Grading plan?
just a grading plan?
Yes.
Thank you.
Sheet number 5 of the 5 of 15 of the site development plan for my K-9 buddy.
Okay, great, thank you.
Title degrading.
Just if we refer to it later, I wanna make sure we refer to the
Thank
right
you.
thing.
Mr. Bechtel, is it a unique feature of this site that that area is restricted from any development? I'm sorry, the easement area that you just spoke to?
Very unique. Yes, very much so. Really becomes unusable.
Well, that was my next question. So as a result of the environmental easements and the environmental features that you just spoke to, is there anywhere on this lot that we could locate this building that would meet the 300-foot requirement?
It is not. The whole lot's approximately 400 feet deep and, we're asking for the variance 105 feet or something in that respect, so.
Mr. Bechtel also prepared this, so I have marked this as applicant's exhibit 9. Mr. Bechtel, can you, I'm showing you what's been marked as applicant's exhibit 9. Can you please briefly describe what that shows to the board?
Scenario photograph of the location of the proposed building for my K9 project, and then showing us some proximity to the nearest residence, which is the Emert residence that we're requesting is very much strong.
That shows effectively a 300-foot bubble around the building. Is that accurate?
Yes, it does.
Okay. I'd like to ask that applicant's exhibit 9, which is that aerial photograph showing the 900-foot, or I'm sorry, the 900-foot, the 300-foot red bubble we entered. Thank you. Mr. Bechtel, can you describe what the status of lot 4A is, which is adjacent to our lot?
Let me point it out here. Not very sure, not now.
Yeah. Basically.
Lot 4A, corner of Meadowbank Road and Prior's Church Road, is part of kind of what we call dead man space for the expansion of the runway for the airport. Yes, yes.
Okay.
Irrigation easement over that.
I don't know if that's to that point yet, but that's the purpose of that, and it's to remain non-buildable. There's a vacant lot to our west, lot 6A, for future development.
Mr. Bechtel, just to clarify Mr. Kraft's question, lot 4A is owned by the commissioners,
It's
correct?
owned by the commissioners. I'm not sure whether it has an irrigation easement.
And would you say that is it your opinion that it's unique to be adjacent to a property that will remain vacant?
Very much so, yes.
Now, the zoning of this general area is such that across Crider's Church, there, from our property, there is conservation zoned property. In your opinion, is it unusual to have industrially zoned property that is adjacent to conservation zoned property?
Typically, yes.
And to the best of your knowledge, has this property, being the subject property, been zoned industrially long before MARTA began pursuing any sort of development of this property?
And doing a little bit of research through the city records and one of the employees there at the city, Andrea, it appears that this thing was annexed by the city in 2003. And it went from the from Carroll County ag zoning to industrial zoning during the annexation process on January the 14th, 2003. The first subdivision occurred then the following year.
And
By the way, it was the annexation petition was filed by the Emmer family.
in your professional opinion, what is the purpose of requiring a distance buffer between uses?
Particularly in the industrial zone, you know, in restricted industrial, think about very intense uses, manufacturing where noise may be a factor, dust may be a factor, large truck traffic may be a factor. Those kind of things. The special exception, the request for a special exception, which was granted here a few years ago, brought up the 300-foot distance. And here again, some of the uses that you might have in special exception might be a shooting range, might be other high noise level, high dust levels, you know, things that may be intrusive to the neighborhood. This special exception is a very low intense use. Yes, there'll be car traffic, but not truck traffic.
And when you say, just as a point of clarification, when you say this brought up, are you saying that the 300-foot requirement is unique to the special exceptions in this zone and not to the principal permitted uses in the zone?
Yes, it is.
So by virtue of this use being classified as special exception, that is why this 300-foot measurement comes into play at all.
Yes, it is.
And MARTA, is MARTA's use what you would consider a traditional industrial use?
Not really, but, you know, traditional, here again, you think about
I'm
manufacturing.
handing you a copy of the IR zoning code too, just for your
Yeah.
reference.
Well, you think about contractors, you think about construction, you think about manufacturing, those kind of things. Now, what's kind of unique to the entire area, that if you look at the airport complex, there's many multiple uses in there. There's very few of the traditional manufacturing manufacturing businesses that are in that kind of that industrial corridor out through there. Shelter systems may be the most intense of any business there, which joins us to the west.
So would it be an accurate summary of what you just said to say that this requested use is less intense than a more traditional industrial
Very
use?
much so.
And from a location perspective, the subject use is also across a public road from the residentially developed property. Is that accurate?
Yes,
Does that roadway also serve as an additional buffer that kind of furthers the intent of the code?
with the 80-foot right of way, yes.
And do you believe, in your opinion, that we can still meet the intent of the code by providing the distance that's been shown on the plan?
Yes, with this particular use.
I think that's important. So it's that your opinion is specific to this use because this
Yes.
use is much different than a lot of other industrial uses. Is that
Yes.
accurate?
It is, and then most of the or all the activities will occur inside the building.
Now, in your opinion, will there be any substantial detriment to the adjacent properties by developing this property at 195 feet from that adjacent conservation zoned property versus 300 feet?
Not with this particular use.
And in hearing in all of your research and also in hearing Marta's testimony, do you believe that not granting this variance would create an unreasonable hardship?
Yes,
Please explain that opinion.
given the economic input that our customers had in this project. It would be an extreme economic hardship to her. She has had a level of difficulty finding a site to do this on, like Ms. Carson testified, that she started in the county, so we're down to here and I don't know, it may go away if this was not granted, I'm not sure.
And part of the reason you say that is because of your previous testimony where there's nowhere on this property she could locate this building and meet the 300 feet. Is that correct?
And meet the 300 feet, that's correct.
So my only question is Mr. Bechtel.
I don't right now.
So if I might ask, can we first ask if anybody has any questions of the applicant? Because I don't want to lose
No,
that
I
right to ask her
Yes.
questions.
I got questions of the last person who spoke.
First, we're doing the applicant, Ms. Corsi, is that?
Yes, thank you.
Okay, I have questions for the applicant.
Can you state your name and your
Sure.
address, please?
My name is Michael Nicola. I go by Mike. I'm a subject matter expert in siting and developing large industrial facilities. I've been retired for a number of years. I developed over $2 billion worth of sites. Some of them were nationally recognized, made presentations, places like Boston and other cities. So I just have a couple of easy questions for the applicant. First question is, what siting analysis did you perform with other sites in which the facility met intended setbacks?
I heard it, but I don't understand it.
Yes, can you repeat or rephrase the question? She didn't understand it, I'm sorry.
Okay, I'll ask the question again. Did you perform a siting analysis? Do you know what a siting analysis
I
is?
The
don't.
subject property.
Okay, so they don't know what a siting analysis is. That means they didn't perform one.
If we looked at any.
Number two,
Where this would.
what other sites did you look at that fell within the established setbacks? Did you look at any?
I had previously looked at a site in the county. And that, for various reasons, I abandoned.
Okay. Did it meet the intended setbacks, that site? I know that you abandoned it, but my question is, did it meet the intended
You
setbacks?
won't say if you recall, it's been some time, but
It's
if
been
you
some
recall.
time. I
you-
believe so.
You can answer
Okay,
that.
so there was an alternative site that met the intended setbacks. That needs to be established as a fact. Next question. You said that it doesn't impose any impacts to the community. Now, if I'm not mistaken, these are dogs in this facility, is that right?
It is correct.
Okay, do dogs give off noise?
It is inside the building, all the.
I asked if
activities
dogs
are-
give off noise. That's a yes or
They
no.
do.
They do give off noise. Do dogs defecate?
They do.
They do. And are owners responsible for cleaning it up?
They are.
And what happens when owners do not clean it up for whatever reason?
Then I pick it up.
Hold on.
I'm.
If it doesn't get cleaned up for any
Offer an
reason whatsoever,
objection.
what happens to that?
I'm gonna offer an objection to the questions for the record. Most of these questions are related to the initial special exception request for the use itself. Tonight, we are not here for the use
Hold
of
on.
approval. We are
She
here
made
for
a
the
statement that
variance.
was outright false by
Excuse me,
stating
excuse
that
me.
dogs have no impact to the community. They do.
Sir, let's let her finish what she
I
was saying.
was finished. Okay, thank you.
I assert that dogs do have an impact to the community. I have a dog. I am a neighbor. I walk by that site. Now, as much as I would like to admit, I'm not perfect. I try to always pick up after my dog, but it does happen. No one in this room is perfect. It does happen. Okay, I do want to establish that. You said something, sir, that was outright false as well, and I'd like to address that.
So are you going to, we're gonna do all
Yeah.
questions of the applicant first, okay? So let's establish if you're done with your
No, I'm not
questions
done
of
with
the
the
applicant.
applicant. My question to the owner is, you knew from the very beginning that this site did not meet the setbacks. And the setbacks were established by the city and the county for years before this site was developed. Many years. You knew about it. You knew it didn't meet the setbacks. What did you do with the design and location of your facility so that it met setbacks? Did you do anything?
I'm objecting to the first part of that because that's not a question. You are making a statement
No, that's a
about my
question. I
client.
said, what did you do?
And I'm fine with the questions, but if you have statements to make, I think those are best made after our presentation.
No, that's not a
And
statement.
as-
That's, I disagree entirely. That's a question. You knew it didn't meet the setbacks. What did you do when you developed a site to meet the setbacks? It's a
That
very
is
simple
a
question.
question based on the assumption that she did not know the setbacks.
Hold on. Her previous answer to my question was, I knew it didn't meet the setbacks on the site. You also testified, you knew from the very beginning, the site did not meet the
I
setbacks.
have a different recollection of her testimony, but I am.
He gave testimony stating that they knew it didn't meet the setbacks from the very beginning. This drawing that they submitted to the board, to this committee, proves they knew they didn't meet the setbacks. One of the setbacks imposes on conservation. That's conservation, that's not other industrial property. When I look at this drawing that you just gave me, sir, and I look at it and you say we couldn't locate it anywhere else, that's outright false. You could have located it to the north and to the east.
Sir,
So my question to the applicant was, I go back to my question. You knew it didn't meet the setbacks. What did you do to meet the setbacks? Did you redesign the building? Did you relocate the building? Did you look at alternative locations? Did you scale back the size of your parking lot? What did you do We would like to know. That's a simple question. I think it's a reasonable question that you have a right to know. What did she do to meet the setbacks?
I was unaware that that setback requirement existed until relatively recently. Yes?
So you purchased, let me make sure I understand this. Purchased a piece of land for an intended use and you didn't know the setbacks? Is that correct?
I have to.
Is that correct? I'm asking her a question based on her comment.
Okay, I have no problem with her answering that question, but the tone in which you are asking that
I have to
question
talk loud
is
because you
problematic.
said you did not hear me. And I'm talking loud so you can hear me. Now, look, I don't want to get into the question or my tone. I'd like you to address my point. It's a valid point, and the community and these people here who make a decision have a right to know. What did you do to address the setbacks? It's a simple question. Answer the question. Don't divert. Stay with the question. I'm not hearing an answer. I think you have a right to know. What did they do? I'm not hearing anything, so my interpretation is you knew about the
I
setbacks. You
object.
did absolutely nothing about it. Okay, I just want to establish that's
Mark Depo approached you about the setback issue.
That was
When did
all-
that occur?
Which one of the
Approximately a
comments?
month or so prior to submitting this application, we had a meeting with staff and discussed the interpretation that arose out of a site plan comment letter. And that's when we came to the conclusion that he was requesting us to apply to this board for that variance. That's when it came to everyone's attention. And I'm happy to ask my client rebuttal questions. But at no point in time did she testify that she is a development expert or that she had done every possible exploration of this site. And I think the board knows this, and I know staff knows this, but I'll point this out for everyone in the room. That Mr. Bechtel has not been the engineer of this project since its inception. He only more recently came on board. So this was previously being handled by a different firm, a different outfit, who had done the work that MARTA relied on them to do to prepare a plan that showed the building where it is. So Mr. Bechtel is here speaking to the plan, but he is not responsible for picking that exact location of that building.
I also believe that there's been some city staff turnover as well. Obviously, since this process began, and I wish Mark were here this evening, planning director, to speak to this. It was an oversight, according to him, by previous city staff that this was missed or this was not recognized until recently.
You guys are running down a very dangerous path. This is a major setback request that she's asking for 105 feet. It's almost 35%. And I live within a mile of this site. My home was built with setbacks, and there's a lot of homes and businesses that weren't. I'll ask another question of the applicant. You knew about these setbacks at some point in time. Your engineer testified to it. He put it on paper for you. It's very clear. Did you look at buying other properties? And if so, did you negotiate with them to mitigate the setbacks, especially on conservation land? That's a yes or no. We did or we did not.
I did not.
Okay.
And the reason is, we looked for this property, or we looked for property for several years. This was the property, the only property we could find that suited our purpose.
Look, ma'am, I'm an engineer just like the gentleman down the street. And I gotta tell you, there's a lot of times you try to solve problems and they're not solvable. So you have to start out fresh. It doesn't matter how long it takes or how many times you try it. Counts as if you solve the problem and get it right. This request is entirely unreasonable. You know it. You hired an attorney and spent a lot of money on an attorney, but where do we see alternative siting analysis and opportunities to say where else you could have located? We understand that there's economic drawbacks, there's costs. You testified for that. I understand that. But the county, the city, were not responsible for your profitability of your business, for your lack of siting analysis, and the complete disregard, 105 feet on a conservation area. That is unheard of to make such a request. It's unheard of.
I need to make sure that I understand your question. You purchased the property in 2000. What did we say?
18, 19.
18. And move forward, and you had drawn up, and then it was just a month and a half ago, 2 months ago, that the issue arose after everything was drawn up. Just to make sure that following the timeframe. Because even when you came back for the landscaping, it was
It
not
was
brought
not.
to anybody's attention.
Exactly.
Okay, well, I have some more questions. Okay. So if you didn't scale back the size, once you knew the setbacks, my question is, why didn't you? Why didn't you come up with some alternatives? You're here asking for approval. I'd like to know if you came up with some, I'd like to know if you came up with some alternatives.
I believe her testimony in the original questions, direct questions, was that the building size is crucial to her business.
Oh, it's crucial to the business. Well then, ma'am, isn't that a fatal flaw if the building doesn't fit on the site because you're imposing on setbacks, on conservation? Isn't that considered a fatal flaw? A siting analysis? I can tell you from my expert testimony from doing this for 20 years and developing over $2 billion worth of sites, that is considered a fatal flaw.
So am I assuming that you actually are one of the neighborings, or where you, I'm just questioning as far as, are you, I didn't catch the address, are you one of the neighboring properties or?
The address, he has it.
Okay,
It's 724 Wilford Court. I am a neighbor.
okay,
I don't like the fact, I'll tell you right now. I wouldn't be here if these setbacks, even though they're large, didn't fall on conservation. The fact is, it falls on conservation. It's not just conservation it falls on. It falls on a church's property and a minister's property.
The setbacks are actually not at all related because
I beg your difference, man. You look at this map right here. It shows it very conclusively. You see it. It's absolutely false. It's proven on this map.
the setback requirement is specific to a dwelling. It actually has nothing to do with the adjoining zoning. We've pointed out that the adjoining zoning is conservation, the adjacent zoning, if you will. But the setback is unrelated to any of the actual adjoining zoning. It's related because that one property adjacent across the street is developed with a dwelling. That is the only variance that is being requested here.
That's precisely
The bubble of the
that's
300
precisely the
foot,
problem.
just to show the obstacles of relocating the building on the existing property, not to suggest that this is, I do appreciate that point of clarity, because that exhibit was not intended to suggest that there is a 300 foot distance requirement of every adjoining property. It is only that one adjacent property across Criders Church that is developed with the dwelling. That's why there's one distance measurement.
And is it
It's
zone
been provided to
conservation? Is it zone
It is zone
conservation?
Yes, it
Okay,
is.
so you need to address this point. She's imposing on conservation. This is not industrial land. Look, I wouldn't be here if all this was industrial land. I agree with much of your testimony, by the way. But this is conservation, it's a church, and it's a church residence. And there are numerous homes just down the street that are going to bear the brunt of that increased traffic. Are you enlarging the street? What are you doing for traffic mitigation?
That, I have
About the
to ask where
order.
that has to do with, because that's already established that it's a variance to approve the use of the properties.
Well,
The special exception was already approved.
Correct.
That's fine, okay, I withdraw my.
And can I also
withdraw
just
my question.
take a moment to say, I have no objection to this gentleman offering testimony of his own as part of this hearing. That's part of the process. If that is the time for him to offer testimony, then I have the opportunity to cross-examine him. It seems like we're getting a little bit blurred between
This
his
is not a court hearing
cross-examination.
where it's a public hearing, it's not a court hearing. I don't have to have your cross-examination. I'm asking questions of the applicant, and I have a right to ask questions of the applicant. I did not finish. You interrupted me.
Questions of you.
Board has the right to maintain order in the hearing. There is a process.
She's been interrupted, the
It may-
attorney's been interrupting me time and time again.
Sir, so right now, according to the board's rules of procedure, right? You will have a time to testify after staff has a chance to make a presentation. We will hear from everybody else. Right now,
Questions from
we
the
are listening to just questions of the applicant and then Mr. Bechtel, and it's related to what they've testified to already.
She said that they had another site. I think that was the point that she made. My question on that, questioning the applicant again. Did you ever contact economic development on your inability to find a site that was large enough, that met the setbacks, and was economically viable for you?
No,
What I am hearing is, okay, I'm gonna reserve judgment. Let me continue with my questions. Did the city setbacks for this site change at any point? You said you took 5 years, you've been here a long time, spent a lot of money on attorneys and engineers. Did the setbacks change at any point in time over that 5-year duration, or did you know they were the same?
as we just mentioned, it apparently was a city oversight when they were putting their comments out to bring that to our attention.
So,
But no, we did not know.
thank you, Principal. So they didn't look at setbacks or change during the application process. Thank you. And you did not look at purchasing other properties impacted by your variance. Is that correct?
I believe the variance was just for that property.
Again, did you attempt to purchase any adjacent properties that were impacted by the variance?
No.
No, she did not. Thank you. Okay, did you talk to your neighbor at 218 Graders Church Road at any point in time during the development process, informing them that you were attempting to develop a facility that did not fit within the site and the established setbacks?
No.
No, she did not. Thank you. No more questions.
Does anyone else attending have any questions for the applicant? Questions for the engineer, Mr. Bechtel?
Yes, I have questions for the engineer. Mr. Bechtel, at any point in time, did the owner say, we have setbacks that you have informed me of? What can you do to redesign the site so that my facility fits much closer than 105 feet? At any point did she come to you and ask you to do that?
No, but I want to add something.
Hold on. His
No,
answer is no, she did not. Thank you. Go ahead.
you go ahead. The answer is no.
The answer is no. Mr. Bechtel, did at any point in time you caution the owner that these setbacks were very large and you could not mitigate them?
No,
No. At any time did the applicant come to you and say, I need to find another site, it's not fitting. Is there anything you can help me with?
no,
This drawing that you submitted to the board, to the committee up there, is there any reason why it can't be located closer to the airport in the northeasterly direction?
we do not own the lot closer to the airport.
So the lot is not owned closer to the airport, and therefore you couldn't go closer to the airport. Is that correct?
You cannot get closer to the lot.
At any point, did you recommend to the applicant the purchase of the adjacent lot to give more room?
The setbacks, the adjacent lot does not meet setbacks either.
I understand that, but did you say to
No,
her at any
the
point in
adjacent
time,
lot will not meet setbacks either.
it will not meet setbacks later? But let me ask you this question. If you purchase the adjacent lot and then combine them into one lot, would they fit the
That
setbacks?
is not an option.
It's not, why is it
It's
an option?
never considered an option.
Why was it considered an option?
That's not for me to answer. That
Okay.
is not an option.
Hold on, but the
The
applicant,
interpretation of this setback was made by the zoning administrator of the city of Westminster just a few months ago, way beyond the process when the use was accepted by this board.
She just explained to me,
And-
this is not a use.
Excuse me, let me finish.
Absolutely.
Really? Let me finish. The interpretation for this setback was determined by the zoning administrator for the city of Westminster. There was some debate about what this setback actually meant and whether it applied to us. Possibly the city staff will address that in their review.
Okay, so the answer I received from you, I want to clarify. They did not look at purchasing the additional property to determine what it would mean to the site and the setbacks. That's all I'm establishing.
No,
Okay, that's fine.
Any other questions for Mr. Bechtel? That. Open up to staff presentation.
No further.
No, I have no further testimony, thank you. I will have a closing
And
statement.
there's nobody that has any further questions.
I have further
If
questions.
not,
I have further questions. These questions are not to the applicant. Who are they to? I want to make sure I'm addressing them. Why?
you may only ask questions of the two individuals who testified.
Two individuals who testified. Okay. Is
As I
there-
said before, you will have a chance to make your own statement later.
Thank you. Are there any mitigation measures that was taken in the design phase to mitigate the sound and the level of dogs barking?
So this is being asked to be you.
who are you asking?
I'm asking who I can ask. I can ask two people who
That
testified.
pertains to the use, not the setback.
So you didn't look at any time into the noise issue of dogs barking?
It's an architectural matter. It'll be addressed, it is being addressed on the architecturals.
So,
It's not a setback related matter.
okay. All right, she said if there's any questions. Okay, so I'm not hearing an answer to my question on noise abatement design issues. Dogs give off noise. And there are noise limitations, but there's no design consideration given to noise from the barking dogs. You said the facility had to be this big. It couldn't be smaller. That's what you testified to, correct? So my question is very simple. It's this big. What was done to mitigate the noise from dogs barking?
I
You
have
said
to
it's an
agree
architectural issue.
that has to do with the design and the original approval of the exception for the use of the property.
Agreed. Yeah, I have no more questions. Thank you for the opportunity.
Okay, we're gonna move forward to the city staffs.
Yes, sir. Thank you. Joe Atkins with the planning department, like to enter the entire staff report into the record. Not to go over what was already mentioned, but just point out a few highlights. In the background, the applicant did get the approved for the use with a special exception back in 2018. They came back in 2019 to request the variance to landscaping requirements. And then, as the applicant mentioned, within the last 2.5 months, it was pointed out that this setback requirement would be required for this property. So what the nut of the problem is that when this use was amended to the zoning ordinance, it was put in as a special exception. So any special exceptions that are approved, the setback triples, basically. It goes from 100 feet to 300 feet. And again, as the applicant or Mr. Bechtel mentioned, that it's typically because of noise, dust, other environmental concerns from what I'm calling purely industrial uses. So that's the reason for the setback. Again, it was just brought up within the last couple of months. I think it was during the 8th review of this site plan. We already know the property zoned IR, industrial, restricted industrial. So the property was posted, it was advertised in the Baltimore Sun, and adjacent letters were sent to adjacent property owners as well. So dealing with the three criteria that you're required to consider, which starts on page 5 of 8. The first one is there's extraordinary or exceptional circumstances or conditions applying to the property in question, or the intended use of the property does not apply generally to other properties or classes of uses in the same zone. Again, the recommends that the applicant has already provided testimony about the unique and unusual characteristics of the property. The zoning administration concurs that the rear of the property consists of steep slopes, wetlands, and a stream, and a forest conservation easement that affects the building's location on the property. The zoning administrator does not concur with the applicant's statement about the right of way of the property, because the right of way is the standard width for a collector road for this type of road. The second requirement is such a variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zone or in the same vicinity. Again, you heard what the applicant had to say, and as I mentioned before, the applicant came twice before the Board of Zoning Appeals. As I mentioned before, the standard setback is 100 feet, but since this use was a special exception, that setback triples in nature and it becomes 300 feet. So if you read on the bottom of page 6 of 8, the special exceptions in the industrial, restricted industrial, include concrete and concrete product manufacturing, ready mix concrete plants, contractors, equipment and storage yards, sawmills, commercial, telecommunication facilities, trade schools, funeral homes, mortuaries, private indoor facilities, indoor dog training facilities, and automobile storage lots, indoor shooting ranges, would require an additional 500 foot of setback. The indoor dog training and event facility is 195 feet from 218 Priors Church Road. So this is, if this was permitted by right, it would be, the setback would have been met, but since it's a special exception, again, it would be, the setback is 300 feet. The third point, the authorizing of such a variance will not be of substantial determinant to adjacent property and will not marginally impair the purpose of this chapter due to, or the public interest. Again, the zoning administration recommends that the applicant provide testimony, which they just did. Zoning administration doesn't concur with the applicant as the specific use of indoor dog training facility or event facility is subject to the distance requirement. There was discussion that prior to submission of the variance, the applicant was arguing that the tripling of the 100 feet did not apply. The zoning administrator made the determination that it did, and so that's why they're here before you tonight. The zoning administration concurs with the applicant regarding the intent of the additional distance requirements. Would like to clarify that all activities associated with indoor dog training and event facilities, except for the vehicle movement of the property, shall occur inside the building. No dog runs or outdoor activities related to the indoor dog training and or event facility can occur outside. Zoning administration notes that the actual residence at 218 Criders Church Road is located approximately 450 feet from the proposed indoor dog training facility. But we measure to the property line and not to the actual building, so that's what that statement is about. So again, as with all cases, the zoning administration recommends that the board carefully review the variance for 2407 and make findings of fact to section 164, 161A3 sufficient to either approve with conditions, or disapprove the applicant's variance. The zoning administration finds that based on the findings and conclusions and recommended conditions in the staff report, the requested 105 feet from the 300 feet distance requirement of the zoning ordinance, section 16458, allowing a proposed indoor dog training event facility to be 195 feet from 218 Criders Church Road, containing a dwelling meets the requirements set forth in section 164, 161A3 of the zoning ordinance, and that is the staff report.
You had mentioned there was a discrepancy in the applicant's report with regard to right of way.
So they were the right of way for that section of Criders Church Road is a collector road, and so it's 80 feet. The road is actually 30 or 35 feet. I think I forget what the actual distance of the pavement is. So while the applicant was saying that was additional buffer, I think that is part of the 300 feet that would be needed, whether it was right of way or not. So it is part of the distance, but they were arguing that it was an additional buffer between the facility and the residential use.
So it wasn't disagreement about the actual right of way.
No, sir, no, sir.
So I guess what I just heard, and I want to make sure, so if it was industrial, we had tractor trailers going in and out of there, all they would need was 100 feet.
For the majority of the uses, yes. The only reason they need 300 feet is because it's a special exception.
Doesn't matter what, as long as soon as it says special exception, it automatically goes to.
Right, if it was a bakery, if special exception was a bakery, it would be 300 feet.
Perfect, okay, just wanted to make sure I understand.
And bakery's not just.
Right.
Yeah, exactly.
And I just want to also make sure we are only talking about this one, there's no exceptions on the other 3 corners of this building. It falls where it needs to be as far as the regulations in the city.
Yes, ma'am.
Okay. Okay. It's been a while.
I have a question on Joe. Joe, can I ask you a question? Is it okay if I ask you a question?
You know, they're up for public questioning.
Joe, you mentioned something about 500 feet. We're reading off that. Can you give us some detail around that? What is that 500 feet you
The
mentioned?
500 feet would be if this property was going to contain an indoor shooting range.
An indoor shooting range.
Yes, sir.
Strictly for an indoor.
Yes,
shooting.
sir.
And this property was in zone industrial, is that correct?
Industrial restrict.
And what is the basis for the zoning of industrial? Is that to promote the development of industry? Is that why it's zoned industrial?
It's zoning is to segregate uses, so yes.
Segregate use, and so when you segregate the use from industrial to a facility that's gonna house traffic and dogs, et cetera, that's a special change, is that correct? You call that a special
It's part of a
exception?
special exception, yeah.
And in that special exception, the setbacks change, is that correct?
Yes, sir, I see it.
And why do those setbacks change and become 300 feet versus 100 feet? Why do you think that is?
Because special exceptions are site specific. So that's why it gives the city a broader ability to regulate special exceptions.
So Now that it's been changed, the special exception,
It hasn't been changed, it was approved as.
it was approved, I'm sorry, so I apologize. So it's now approved for a special exception, which now means that an industrial facility cannot be located where she's going to put her dog training facility. Because a dog training facility is gonna be built there. It's been approved by special exception, correct?
If she moves forward with the project, yes.
So if she moves forward with the project, the city loses that land
That's
for
testimony.
industrial use. Is that correct? That's what the change was approved for, right?
Don't understand your question.
The change was approved for special exception, right? Which tripled her setbacks,
Yes,
right? That's correct.
yes.
Now, if she goes forward and the board approves it, then that means that land can no longer be used for the original intended use of industrial, correct? She's putting a dog facility there.
But it's still a use that's permitted in the industrial zone, though.
It's a use that's permitted, right? But it can no longer be used as an industrial site because now there will be a dog training facility on it.
That's testimony.
And that's correct. Because they approved the change.
Well, anytime you put a site,
You're asking him to speculate about something, right?
No, this is not speculation. If she builds a dog training facility, that land can never be used again for industrial.
That's not, that is something you're allowed to testify to.
That's a
when it's
fact,
your
that's a
turn.
fact. If she builds this facility, there's not gonna be any
Okay,
industrial
so
built
when
on
it's
that
your
land.
turn to testify,
Okay.
you may make that point.
Okay, thank you.
All right, so next is any supporting testimony. Is there anybody in the public to support the applicant? Then it would be opposition.
I
Opposing testimony.
oppose the project based on the grounds of my questions. And I can go through those factual reasons why. And that is 105 feet variance.
Can you state your name again? So since
My name is
we're gonna have you
Michael Zacola.
testify.
I'm a resident. I live within a mile of this facility. I walk my dog by it a couple times a week. I have a dog and I like dogs and I like this kind of a facility. But I don't like the facility here. And there's basic reasons why. It doesn't matter how many corners it meets. That variance affects conservation. That's a precedent that the city will set. 105 feet, almost 35%. That is a huge setback. It is unheard of. It's absolutely unheard of. The applicant testified she did not do a thorough job citing, evaluating, looking at alternatives, buying other lands, hiring a siting and development engineer that does do this for a living. None of that was done. So therefore, that's called gross negligence. They didn't do their homework. So what they thought they would do is ask for a 105-foot setback that affects conservation. These are facts. The fact is also that although the intended use has been approved, if you look at the map that they provided you, it clearly shows that they have gone beyond their limits and that there are homes, including one home's property that is impacted by it. There will be traffic. There will be dogs. Dogs go to bathroom. Dogs need space. That's going to happen on this site. It's going to affect the land. Might not be detrimental, but it does affect it. If this facility gets built, you now reduce to the city the opportunity for other industrial facilities that could come in and pay the city and the county a great more deal tax revenue, bring in much higher and more paying jobs because you are eliminating the use. You are taking a finite amount of industrial zone land that the city has. You're going to put a dog training facility on it if you approve it. Instead, that land was zoned industrial to bring in industry. The applicant testified they never talked to economic development. They never looked at other sites. Put this facility here. You are shortchanging the city on tax revenue and jobs. I submit that Westminster City is in an excellent location. It is in a prime location. It is close to the Washington-Baltimore corridor. It is close to airport, roads, bridges, and great infrastructure. Guarantee you, by putting a dog training facility in industrial zone land, you're going to shortchange the city, tax revenues to the city, and jobs to the city. It's the wrong location and it's the wrong use of the site. She testified, they knew. The engineer testified, it couldn't fit on the site. They knew it didn't fit on the site. Yet they continued, they hired an expensive attorney to try to change the rules. Instead of saying it doesn't fit, we got to find a site that fits. It's industrial zoned. It's industrial zoned for a reason. That reason is economic development. Don't shortchange the city of jobs, of tax revenue. You don't know the future and I don't know the future. But I can say this, we got an airport next door. That airport just expanded. We got a new road that was built right around the corner from there. This county is growing, it's expanding. That's the wrong location for this facility. Doesn't fit, it impinges on conservation. And I am here to represent not just myself. The Bolton Hill Homeowners Association has over 240 homes. Many of the residents couldn't be here tonight. I speak for them. There are many people that do not want this facility there. That's why I came out with my questions. That's why I challenged the attorney and the applicant and the engineer. We don't want that facility there. It's the wrong use, it doesn't fit. Planning and zoning group came out and said it's a special variance and it doesn't fit. These are the facts of the case. They don't change. To approve that site, you're going to regret it. Not now, years from now. It's not going to make the residents, many residents, unhappy about what you do if you approve this location. Rest my case.
Any other? Well, now it's time for rebuttal then, if nobody else is gonna testify.
I am not going to offer rebuttal testimony. I just have a closing statement. Thank you. So with that, I think we all understand this, but I will reiterate it just in case, that the special exception has been approved. And this is a use that is allowed in the zone. We are here tonight looking at section 164, 161, which governs variances. And you heard lots of evidence and testimony put forward that there are extraordinary circumstances or conditions related to this property that do not apply widely to other IR zoned properties. Some of the testimony you heard was related to the width of the right of way and the impact to this specific property. The fact that this property adjoins property dedicated and preserved for the airport, if you will. The topography and environmental preservation of the rear of this property, which greatly impacts the development potential of this property. The exhibit that was put forward shows approximately a 130-foot area, which is pretty monumental in considering that the entire width of that property is only about a bit over 400 feet, as Mr. Bechtel testified to. This is also unique because it's industrial zone property that adjoins or is adjacent to conservation zoned property, which is not why we're here. We're here because there's a residence there. The way the code reads is such that when that conservation zoning is developed residentially, this variance is necessary. That's been the interpretation by the zoning administrator, and that's why we're here. To the second criteria under that section of the code, which requires that the variance is necessary for the preservation and enjoyment of substantial property rights possessed by other properties in the same zone and in the same vicinity. You heard testimony that this use itself is much less intense than many traditional uses in traditional industrial uses and uses that are allowed by right on the property. this, just to, I know we've gone over it a few times, but a truck or motor freight terminal or warehouse is a principal permitted use that is only subject to 100-foot distance requirement. I would submit to you that that has much more intensity, potential for noise, odors, dust than the use that Ms. Corsi is proposing. And so not to say that the distance doesn't apply to us and that we don't need to be here, but just to say to you that there are uses that are subject to even lesser distance requirements than this use that have much greater potential to impact those properties. And that's not the use at hand, which is part of the reason I think it is appropriate for you to grant this variance here tonight. I think one of the most powerful pieces of testimony that Mr. Bechtel put forward is that this building, well, first of all, Ms. Corsi put forward that the size of this building is crucial to her business. But the second component is that this building cannot be located anywhere on the site that meets the 300 feet distance requirement to that one property. I understand that there's been some testimony offered that perhaps other properties could have been evaluated, properties could have been joined together. I submit to you that that's irrelevant for tonight's consideration. First of all, had the two properties adjacent to each other been adjoined, it actually would have been closer to that dwelling than our property. So that would not have eliminated the need for any sort of variance. In fact, relocating the building onto that property would have created an even lesser separation between the uses, if you will. So the third prong of that section of the code requires that the authorizing of such variance will not be of substantial detriment to adjacent properties and will not materially impair the purpose of this chapter or the public interest. The testimony that you've heard both from Mr. Bechtel and Mr. Adkins here tonight support that the intent of the code in creating these distance requirements is to create a buffer between uses that might generate some noise, odors, and dust. And again, this is not an intrusive use. Ms. Corsi, there might be some disagreement, but Ms. Corsi testified that any noise from the use will be contained within the building and will not impact adjacent properties. And as she testified, this is not a new industry to her. This is something she has a lot of experience in her current site as well. So there is no noise, odors, and dust that are going to negatively impact adjacent properties. And then again, that Crider's Church right-of-way area just provides an additional buffer, not to say that it negates the distance or somehow changes that calculation, but you could be in a situation, the reason I say it creates an additional buffer is because you could be in a situation where you're requesting a variance like this of a property that literally adjoins your property line. And I'm just pointing out that in this case, that's not what's at issue. This property is across the road. The relevant property is across the road from our site. And I think that's an important consideration to make under that section of the code. We understand and respect the zoning administrator's interpretation here related to the distance requirement, but I would respectfully assert that the location of 195 feet from this dwelling is not a cause for concern because of all of the elements that you've heard testified to, but also those other uses that could be much closer, that are much more impactful than this use. And just to clarify a few items that were testified to, BZA cases do not set precedent. Case law supports that BZA cases do not set precedent. And so, because the entire point of your analysis is to look at this specific property and all the specific testimony that was put on related to this specific property. So I don't want there to be any confusion that because this one variance has been granted now across the city, everyone gets a variance. That's not how this process works. There's also a lot of case law. We have this guidance in the city code related to the variances and the legal standard for variances. But let's not forget that there's also lots of case law that speaks to the legal standard for variances. And first, I'll say to you that I think all of the testimony here tonight supports the granting of this variance. But second, I'll say to you that case law goes into what is required of a property owner in terms of seeking a variance. And it is very clear that it is not required for a property owner to extinguish all other potential sites before requesting a variance on one site. So it's been suggested or implied that my client has disregarded her due diligence by not trying to acquire other properties. That is not the standard that is before this board here tonight. That is not a legal requirement in order to assert a variance request. There's also, I think this is important. I do a lot of these zoning cases and I appear more frequently in front of the County Board of Zoning Appeals, but I think it is very important to point out that there's been no testimony offered from the property owner who this variance is being requested from here tonight. There was some discussion of the economic impact, and I'm not gonna go deep into that, but I do want to remind you or request that you take judicial notice of the testimony from some of the previous cases, because Ms. Corsi really did get into how this will benefit the city and the amount of customers that will come and that will then go eat at city restaurants. And I think that this is a really exciting and unique opportunity for the city. And I also would suggest that that's part of the reason that the text amendment passed and went through, because this was a unique opportunity for the zoning district. And just very quickly, I'll finally say that I appreciate Mr. Atkins' staff report. And the staff report concludes that we generally meet the requirements of the variance standard. So I think with all of the information provided to date prior to tonight's hearing, and then the testimony that's been put on tonight clearly meets the variance standard, and I would respectfully request that this board grant the variance that's been requested here tonight. Thank you very much.
Personal opinion, whatever, I wasn't here for the original, I was here for the second landscaping. But a lot of the testimony appears to me, again, is that it's more for the use than the amount of the setback, which I don't know who was here at that point in time, but that's not what we're here to discuss. I just need to remind myself that we're talking about that. Yes.
You know what I'm gonna tell you, you need to look at the variance criteria, you need to go through each one of them and articulate how the applicant has met or has not met their burden of proof with respect to each criteria.
And so we will be addressing 164-58.
Well, 5E, so if you go to 164-58. Yeah, I can't go to 160.
Sometimes it won't let you click into some of the things.
It's just there. So 164-58 is the additional distance requirements, right? So all special exception uses except those provided in 164-54A must be located 3 times the distance requirements specified in 164-140. And then it goes on, talks about an indoor shooting range being 5 times, and then all other uses are subject to 164-140. So when you go to 164-140, it says any uses of buildings subject to compliance with this section shall be located at least 100 feet from the other lot in a residential zone or in any other zone which contains a dwelling, school, place of worship, or institution for human care. But what I need for you all to look at is or are the criteria for granting the zoning variance, which is 164-161. Because that is what you're charged with in 164-161 with your power and duty to authorize upon appeal in specific cases such variances from the terms of the chapter as are necessary to avoid arbitrariness And so that the spirit of the chapter shall be observed, substantial justice done. And then if you look at A, such variances shall be authorized by the board only upon a finding by the board that those three criteria. So those are the three criteria that I need you to address. Relative to whether the applicant has met their burden.
And I do think with the environmental sensitivities of the property towards the rear, that is certainly an extraordinary circumstance. But the application certainly limits total use of the entire property. And I also believe that given the past rulings and histories on this property dating back, I believe it was 2018. That this variance is necessary for the preservation of enjoyment. Substantial property rights. Basically, the setback and shouldn't be. Pretty large setback, I think 195 feet, basically 2/3 of that, I believe is substantial. I don't think it would be a detriment to adjacent properties to have a 200-foot setback for this particular use, especially given that there will be no outdoor runs or anything of that nature, strictly internal facility.
Discussion?
Variance required 300 feet for the special exception. Down to 195 feet. For that particular site.
I had a hard time hearing that lyric.
Basically made a motion, grant the variance from the required 300 feet for the special exception down to the 195 feet.
For the recent state.
Motion in a second, all those in favor?
Aye.
One.
The other business? I'm not the chair. Tend to take over.
City staff, do we have any other cases pending for us in the coming months?
We are expecting a case for November. Yes, sir.
And with that, I'll entertain, any other business or tentative, I'll entertain a motion for adjournment.
Sure.
Been moved.